everybody. Welcome to yet another video session of the Column of Curae. Today, we will discuss about the demand of educational fees amidst the pandemic. And we have with us Ms. Priyanka Agarwal, Advocate, High Court of Calcutta, as the guest speaker. Ms. Priyanka Agarwal is a medical aspirant turned lawyer and a 2019 graduate from the Department of Law, University of Calcutta. Apart from holding extremely good academic records, she has a plethora of experience in financial crimes. She is also a social and a human rights activist. To add feathers to her professional record, she assisted Mr. Vineet Ruya, a social worker himself, in drafting and briefing the landmark COVID dead bodies case before the Honorable High Court of Calcutta, which was later cited by Honorable Allahabad High Court while taking cognizance of the Hathras gang rape case. Currently, she is the advocate on record and arguing counsel in Vineet Ruya versus State of West Bengal, infamously known as the school fee case, sub-judice before the Honorable High Court of Calcutta. Thank you, Ms. Priyanka Agarwal, for taking time out for the legal discussion with the Column of Curae and being there to enlighten young, bright minds.
It's an absolute privilege, team Column of Curae. I really look forward to answering all your questions because I take it as a medium to spread awareness on these very important issues. So please go ahead.
My first question to you would be, please briefly explain your cases in light of protection of children's right to education vis-a-vis online medium of education amidst pandemic.
I don't know if all the Indian citizens are aware of this, but right to education is now a fundamental right of every child between age 6 to 14 years of age. And this happened after this right was Article 21 in the Constitution as Article 21 Part A, making it a fundamental right, thereby making it the state's duty to impart education to all such children free of cost and of course compulsorily. So every child has this right to avail education till the age of 14 years. But as came forward in the pandemic, that along with all other factors and facets of life, even education was suspended for a considerable period of time. And classes were practically completely suspended, and then later on online classes were started. So this brought to the fore a lot of issues vis-a-vis the fee being charged in this period, because some months were missed by schools and the schools remained completely shut. And after like 2 or 3 months, or in some schools after 4 months, online classes were started, and then schools started demanding fee. Now, the main issue that most parents felt was they should not be asked to pay for the services that they were not enjoying, or the facilities that the schools were not providing, because online classes are fairly restricted in their, I would say, quality as well as quantity. So I think it was a very major concern, and especially because almost everybody had taken an economic downhill journey in this pandemic. It was a very gruesome time for most parents because they had either faced job losses or business losses. So everybody was concerned about this. Then what happened was very unexpected, because schools which were supposed to act as, I would say, the harbingers of education, or you could say they are the ones who are nobly and morally and ethically in every which way required to impart education in a charitable nature, because that's the nature of the law in India. That's imparting education is basically charitable. It has to be charitable in nature. So it was very shocking when very many elite schools in Calcutta started expelling students for non-payment of fees, and not only expelling them but doing so publicly in a fashion that was quite humiliating and very traumatic for the young minds, as you all call it, and it was not good for child psyche in general. So parents started gathering ground, and they formed a group on Facebook that goes by the name of COVID Protest Against School Fees in COVID. And very quickly it gathered traction, and after about 15,000 parents had joined in, they added Mr. Vineet Ruya to the group, who is a social activist and is fairly active and very passionate about issues like education, women safety, and of course he also had just finished fighting for the COVID dead bodies case, almost in the finishing end. So he was asked to help the parents to fight the case in court, because The parents had exhausted all options by writing mail after mail, letters after letter to school authorities, to the state government, to the Child Rights Commission. Almost every avenue they had approached, and they had been disappointed. So that's when they thought that the judicial route is the only way out. And Mr. Roya was engaged, and he then asked me to be the advocate in this matter. And we got to preparing. And when we were preparing, it was very quickly revealed to us that the reason that Bengal schools are acting so whimsical in their conduct, and they were just giving off, I would say, 200 rupees off, and then saying we are done with our share of duty, and now you pay the rest of the amount, or we will expel you. So all that was happening, and the reason behind that was that there was a clear absence of any regulating law for these unaided private schools. That was issue number one. And then when we were researching, it came to us that, the government schools, which will be shocking to most of us privileged people here, that 70% or 72% of the school going population of India goes to government schools. And the same is for West Bengal. Only about 28 to 30% would go to the private schools. And what was happening in the pandemic is that online classes were being given to the private school students because they had the means for it. But the government schools were absolutely under lock and key, and these students had no way to, or the infrastructure to access online education. Neither the schools were providing for the same, nor the state government was, responsive on the matter. So we decided to couple these two issues up, that private schools need to be regulated, and fee charged by them in the pandemic especially needs to be limited to the services that they are providing. And the second issue was that the government should ensure that even the government school students are not jeopardized, and they are not discriminated against. So these were the two main prayers in our case. We filed it, and it's interesting, as a journey for me, because when we filed it, it was on the 21st of July. And by that time, in the Calcutta High Court, there were already, I think, 5 to 6 petitions on the same issue. But either they were not admitted, or they did not receive any favorable order. So our case was admitted in the first go, and we were being heard in front of a very, I would say, glorious bench. Justice Sanjeev Banerjee and Justice Maushami Bhattacharya. Both of them are very, I would say, they have their heart and mind both in the right place. So we were very enthusiastic. And in the very first hearing, they heard us for 90 generous minutes uninterrupted, and they passed an interim order that parents were to pay only 80% of the fee. And I think the reason behind that 80% quantum was that there are different varieties of schools in Bengal. Every school cannot be seen under one lamppost. So it had to be depending on the infrastructure, the fee structure of the school, what is the scale of the services provided by the schools. So without seeing data, at first they could only give an 80% quantum of payment in the first hearing, and then slowly the matter just went. I think it had a very steep growth curve, and then a lot of things happened. And I'm very happy that now we are at a stage when we can say that almost all legal arguments are done, and factual discussions have been made. The judges have understood our prayers, and hopefully in the next 2-3 sittings, we will reach a good conclusion and a fairly generous reduction for the parents. So that is it. That's a very brief gist of the issue, and if you have any further questions, you may ask.
After filing a petition for around 30 pages, what made you file a supplementary affidavit for around more than 100 pages? And also for the fact that even Hon'ble is coming down to argue the matter in favor of some schools. What are the recent developments to the case?
So when we were filing the case, and when the main petition was drafted, we tried to only restrict it to the COVID pandemic situation, because we wanted our prayers to be very specific, and we wanted immediate relief for the parents in the form of a reduction. So we only concerned ourselves with the very primary issue that schools were not providing so and so services, so they should not charge for these things, and only proportionate fee should be charged. And one thing I just forgot to mention earlier was that on the day that we filed the case, the very same day, the day that we gave this petition to the state government, the very same day the government issued a circular that said, that was on 20th July, that said that schools cannot charge anything more than tuition fee. They will have to give online classes to all, irrespective of non-payment of fees, and they cannot charge for these several heads which they were not providing services for. And we were really thrilled at that point of time that at least the petition had some effect and the government had responded. But then we noticed that the words mentioned in the circular were very mischievous. It was like, the schools are advised to do so and so. We request the schools for so and so. So basically, the legal understanding of that would be that it is not enforceable. By that, I would mean that if the schools violated such a circular, then nobody could pull them up in court or in any other avenue seeking for such implementation, because they are not legally bound to do so. So it became clear to us that the reason that these circulars are not binding and are in the nature of an advisory or a request is because there is no law in West Bengal, because education is a state subject, right? So education regulation has to be by the state government. The central government can make as many laws as it wants, as you will also see in the case of National Education Policy 2020, which is fairly well structured. That's been formulated by the central government. But until and unless the state government here accepts it, ratifies it, adopts it, it will not be implemented in West Bengal. So that was the main issue. After filing the case and after seeing these, new, I would say, updates, we thought that we should now make a case, a very strong case rather, for uh, all details as to what happens when there is a lack of law or where there is a legislative vacuum, because clearly that was the case in West Bengal. Plus, we had to also argue about the fact that this petition that we had forwarded was not a random off-the-desk effort, because in this case, in the group that we have with us, the Facebook group with the parents, it has almost 19,000 members now from, and we asked them to fill forms for the schools that they were coming from, and there were 145 schools, and we were getting extensive inputs from parents, and everybody was looking at this case with all their hopes. So we wanted to draw out a case that was more fortified with facts. So we engaged our chartered accountant parents in the group, and we asked them to, sort of audit the statements from the schools. I mean, not their financial statements, of course, but whatever was available through parents' resources and the websites of the schools. So in this supplementary petition that was filed after the writ petition, we tried to chalk out all the facts, discuss all the facts to show how much in excess the schools were making, even though they are required under law to act as non-profit bodies. But it was definitely not the case. We saw that there were some schools that were making 200% profit. And I'm not kidding. There are some schools which have hundreds of crores of corpus, which is a reserve fund that they have. Over years, they have generated that amount of profit. So all this came up later on. So we added all this in the supplementary affidavit. Then we also argued as to what happens when there is no law. Because see, what happens is when you're fighting such a case, you need to give precedents. You need to give examples. So whenever we were looking for examples, I could see that other states could easily implement a restriction on fees because they had a law. Like Gujarat, Tamil Nadu, you would say Punjab, even Delhi. Then there is Assam, Chhattisgarh, all Rajasthan, all these states have a law. So it was fairly easy for the government to pass orders. And then when such orders were challenged in the High Court, respective High Courts, they were very easily upheld. But our main problem, or rather the one task that was very difficult for us, was to make a case for what happens in the absence of a law. So that is what we did in the supplementary affidavit, along with the facts. And other thing was that we had to really make a case for the maintainability of such a writ petition, because it is rather surprising that, even though the nature of this case was such a huge public interest matter, but the defense that was coming in from the schools was directed at the petitioner's intentions. Like they were saying that the petitioner is being motivated under political parties influence, and then he's publicity hungry. He's doing it for such and such reason. He wants to do it because he wants to attract mileage for himself. So all that was happening, and then they said that this writ petition is not maintainable. So we also had to then, as per the proceedings go on, you have to supplement your writ petition to cover all bases. Basically, that's how I would put it. So the supplementary petition was intended to clear all such grounds, so that in case we are challenged later on in a higher forum or even in this court, then we have it in writing as a record before the court. So that's what we did in the supplementary affidavit. And since you mentioned learned senior Mr. Shyam Dewan, so he has been appearing in this matter on behalf of a group of schools, which is the Church of North India Schools. So they are a group of convent schools, but there are two associations in Bengal. One is the Church of North India and one is the Anglo-Indian group. So he was representing the 11 CNI schools. And it's very, again, interesting for me that after we were done arguing upon the maintainability of the case, and after the judges had set up an independent committee to look into the financial accounts of the books, after it was decided that schools had to give a further reduction to parents generally, and then a case-to-case reduction to special case parents who are really suffering. So all that was decided, and then Mr. Shyam Devan stepped in on behalf of these minority schools, and he went to the Supreme Court with a special leave petition saying that these orders do not apply to his schools because they are a minority group. Thankfully, the Supreme Court did not entertain it completely. They said that all orders are valid on this issue and they would not interfere in the matter. But the last order, wherein the audit of these schools' accounts was mentioned by the honorable judges at the Calcutta High Court, that order they could challenge before the High Court itself, but the High Court will be the deciding authority on this. The Supreme Court will not interfere. So then he came back to the Calcutta High Court, and then he just evaded arguing on that issue, because I think it's a fairly settled law that minorities definitely have a protection, but they do not have a privilege. It is settled that the rights given to them under Article 26, 30, Part 1, and other various special protections, they are all in the nature of a shield, and it's not a sword that you can use against regulations. And especially because education is a state function, Indian law especially has this at its core that education has to be provided by the state. It is because the state has failed in its duty, not just Bengal, state as in our government as a whole, and because the state has a lot of financial problems and constraints, that is why they pass on this duty to the private bodies to perform this on their behalf. This is also a very good GK question for you, or information for you, that before starting a school, every private school has to take an NOC from the government, state government. So NOC is what? It's a no objection certificate. So basically they are performing a duty that is delegated to them by the state government. So the state government definitely can regulate these bodies, even if they are minority or majority, doesn't matter. So Mr. Shyam Devan gave a template of suggestions that we will not charge any fee in the pandemic. After the schools return to normalcy, then we will start requesting parents to pay up. And even for that, they will have a scheme of easy installments spread out over 3 years, 5 years, 10 years. So he just basically came up with a very good template. But when then he was asked to file a compliance affidavit, that's when things changed a little bit. And it was made on a case-to-case basis, and the school will decide who gets to avail what benefit. So then we rejected it, and it so happened that his template then rolled over, and even the non-minority schools then said that why should we be discriminated against? Even we want to tag along and provide our own templates. So then all that happened, and then a lot of discussion about the minority issue. But after that was done thoroughly, now we are at a place when the judges have asked us to submit our, I would say, template of suggestions, because now legal arguments are mostly done and settled, and the judges are convinced that there is need for a reduction. So next hearing, we are going to present our suggestions for the parents, and of course, we have taken all inputs from the parents themselves. So that's the current stage, and we hope that our suggestions are used by the court.
Payment of institutional fees amidst corona pandemic, an issue being a matter of national importance, do you think this matter would have directly been taken to the tax court? If yes, how different would it have been for you to approach this case?
So there are two things that regulate education here in India. One is the Right to Education Act, and there is another one which is the National Commission for Protection of Child Rights. Now, there is a limit, or I would say there is a little exception to the RTE Act, which is that the RTE doesn't apply to minority schools, but the National Commission for Protection of Child Rights and the rules made by this commission for fee regulation, it applies to every child. There is another thing, RTE applies only till the age of 14, but National Commission's model for child rights, it applies to all till the age of 18 years old. So we relied on both of them. Of course, so therefore your question that such a regulation or such a case, it should be implemented both on the school stage, at the school stage as well as colleges, all educational institutions basically. But our case is limited to the schools because that's the group of parents that approached us. And the second thing is that such a case or such a writ petition can only be filed in the state level because you would be aware that there was a case before the Supreme Court which was filed on behalf of 8 states parents associations, but the Supreme Court did not entertain the petition because they remarked that they cannot pass an omnibus order. Now what they mean by that is that first of all, every state has a different standard of education. Like I told you, education is a state subject, so they all have different policies for their own their state's education. And then second, each school has a different level that it operates on. There are some schools which are only for the elites. There are some which tender to the middle class, and then there are some which are for even those who cannot pay, and these schools provide scholarships and free ships. So it depends on the scale of the school. Therefore, there cannot be a unanimous omnibus order. Therefore, the Supreme Court then directed the petitioner and the parents to approach their respective state high courts, which is why we chose very first thing to do was that we should approach the Calcutta High Court because our parents were from Bengal, in and around Calcutta, and mostly cities. So I wouldn't say that the preferable choice would be to approach the Honorable Supreme Court, because even though it is the apex court, it cannot regulate school fee across board. And there is another reason for that, which is very important, is that writ petitions are filed under the writ jurisdiction of the High Court under Article 226 and the Honorable Supreme Court under Article 32. Now, both protect the citizens against violation of human rights. But very interestingly, and I would say it's laudable, that the High Court has a fairly comparatively higher power in this regard than the Supreme Court. So Article 226, it has a lot of inherent powers, and that's very important to understand that the Honorable High Courts of the states can do almost anything. They can reach anywhere where they can find injustice happening. They can also entertain writ petitions against private bodies, public bodies, so for sure. They can do it for protection of fundamental rights, non-fundamental rights, as long as they're convinced that there has been some injustice done. But that's not the case for Article 32 before the Honorable Supreme Court. Supreme Court only protects fundamental rights, and they're also against public authorities. So then it becomes really restricted. You can't make schools a party in those cases. So that's how it goes. So I think the High Court is the best option for such cases. Also because then the court is very directly responsible for what's happening in the state, and they can direct the state government to do an in-depth analysis and study on the matter. And the Supreme Court would just, not be the best forum for this.
How do you envisage the difference between compulsory education and compulsory schooling, as you have mentioned in your writ petition?
So compulsory education is what is promised to every child in India under the age of 14 under the Right to Education Act. Now, schooling means something different. It's a structure, it's an institution, which is a school. Children go there, they gather whatever they can, they come back, and there is a routine that they follow. That's a school. That's the schooling system, which is why students who don't go to schools are said to do homeschooling. And it's a wrong term. I would say it's home education, not homeschooling. So, education is basically an opportunity that every Indian child has as a right. It is an inviolable right and it is a universal right, I would say. So, your status is no bar, your capacity is no bar, your age is no bar for primary schooling. So, all that is there. But schooling, now it depends on what your parents can afford to provide for you, where they can send you. So my contention in the writ petition was that if the child is promised education free of cost compulsorily till the age of 14, so then why should a pandemic disrupt the whole system? The state government should ensure that it is imparted. Education is imparted, regardless of the schooling system. Yes, the schools are shut down. Yes, the schooling system has collapsed, like the other areas of all our lives. But education should not collapse, and the state government should ensure that this is continued uninterrupted. So that is the difference between compulsory education and compulsory schooling. Now, I'll add one very quick point to that, that the central government had actually formulated a rather progressive idea for this, which was that there would be one nation, one channel, one education. And there would be like different TV channels that would cater to all classes from 1 to 12, and everybody can watch those lesson programs on TV so that there is no discrimination. It was to start from August. It did not, because of course there was lack of cooperation, but it was a good idea. So that's what I meant by schooling and education.
That's quite an interesting answer, actually. You have also talked about inappropriate fees structure being charged by educational institutions in the same petition. Can you explain why and how do you calculate the fee structure to be inappropriate?
So first of all, the fee becomes inappropriate the moment the schools start charging for the services they are not providing. It's not common knowledge, but schools in India are supposed to run as charitable organizations. They are supposed to run at a break-even cost. They are supposed to not make any profit whatsoever. So, if in the pandemic you are not incurring costs as usual, you have reduced expenses, then why charge the same amount to parents when the parents are already suffering a financial hit? So it becomes inappropriate, disproportionate the moment you start charging for the services you are not rendering. The other thing is that since Bengal doesn't have any cap on the fee that can be charged by unaided private institutions, therefore, in any way, Bengal is an outlier in this situation. We are, at the hands and mercy of the management of the school. I am not saying that it is criminal behavior, because private entities need to operate to make it more, to just expand the horizon, to make opportunities available in a better fashion. But the law of the land doesn't sanction this system. Private institutions are allowed, but they are not allowed to make a business out of it. So commercialization of education is a strict no-no for the Indian system as per the law. So any schools seem to be making it a commerce or charging exorbitant fee is supposed to be answerable. So that is why the fee being charged in the pandemic was disproportionate and inappropriate. And the same has been said by the state government. So I'm not saying that the state government has not done anything. They've actually been very at par with our prayers, and they have issued a lot of circulars. The only problem is that there is no enacted law, so those circulars are not enforceable.
That the educational institutions did not even take into consideration the massive dangers of cyber threats. What can be the possible cyber threats that you can imagine that a student might face, and how can one cope with it?
When we were in the process of drafting the petition, and also in one of the hearings during one of the proceedings, we had complaints from parents in writing, and I'll not name the school, but a very elite school had issues with their software that they were using. And this school had actually purchased an internal software for the school for the specific purpose of providing online classes. And it was an all girls school. But what was happening was that during the online classes, in front of the teachers and all the students participating in the class, lewd, I would say, files were being uploaded to the screen. And it was, of course, against modesty. It was, of course, inhuman. And it was, of course, a crime. I'll not even need to describe why. But it also resulted in a spillover effect. What was happening then was that, of course, the teacher disconnected that class, and of course, they conducted an inquiry for it. But because every girl student is participating in such a class, the links to their email IDs or whatever they used to connect with these online classes had become public knowledge for the perpetrators of this crime. I'm not saying it's very easy to hack into these things, but the ones who can, they can. So then the students were receiving mails and messages after the class was over. All this was happening. Sometimes in the middle of the class, an external voice was making comments which were not, you know, I would say, best suited for the age group. So all that was happening in this one school. We thought it was an individual example, but then it came, more and more parents came to us and they told us that after the online classes, their wards accounts were hacked, and then they were receiving friend requests from random people on Facebook and other social media platforms. So basically, it was like connecting onto a platform which is susceptible to infringement, and then there is no protection for it. And this was in case of very renowned schools which could afford to have their own softwares. What happens with schools which are using Zoom platform, Google Meet platform, or any of these, I would say, free platforms? It's not the platform's fault. It is actually one of the cons that comes naturally in such a system. And if we are to shift to an online education platform, then it is the duty of the teachers and the school management to ensure that it is foolproof. Of course, there are meetings happening in the corporate world via these systems, and they ensure that the system is very nicely modeled and security is ensured. So why not for the schools? If we have seen in the affidavit that we've received from schools that they're charging for the software that they use for the online classes, so then make it absolutely safe for the child. That was a very big concern. And to protect the children from these issues, we actually wrote to some of the schools. We received some responses. I'm not saying that they were unresponsive, but it was a major concern in the initial 2-3 months. I think it has waded now, because now it's become new normal. So everybody is participating in these apps and classes.
Now, just as you have mentioned previously in your statement that National Commission for Protection of Child Rights developed a model fee regulatory framework for unaided private schools. Can you please examine the pros and cons of the regulation guidelines and highlight few provisions of the framework?
So the NCPCR, or the National Commission for Protection of Child Rights, had issued a model fee regulatory framework, and the powers were given to this committee or commission under the Protection of Child Rights Commission Act, which is 2005 Act. And it's not concerned with education per se, but it is to do with everything that affects the child's rights. And since education is one of them, so this model was given out by this commission based on the regulatory frameworks that were already in place in several states in India. And it's not like this model came out first and the states then enacted a law. So Delhi has a law from the 1970s, and then Tamil Nadu was one of the first states to enact a law after the RTE came into place and after education became a fundamental right of the child, which was in 2009 that Tamil Nadu Act came into place, and then several others followed. So the National Commission of Protection for Child Rights, after following all these developments, then issued the fee regulatory framework, because it was receiving a lot of complaints from parents saying that schools were charging whatever fee they wanted to, and which was not commensurate with the services provided in the school. And there were several states which still had to implement or enact a law. So then the NCPCR gave out this model and asked the respective states to follow this as a demonstration and then implement as per their own state's grievances and issues. So when this came out, I think it is a very apt law for the purpose that we are seeking here, and it mentions very detailed structures to follow from the school side as well as the parent side, and for the benefit of the students, of course. So they propose that a district fee regulatory committee needs to be set up at each state's district level. Now, this committee will study the scale of the school, the infrastructure of the school, what services it provides, and thereby devise its fee structure, so that the school is also not disadvantaged and the parents also are charged the rightful amount. This committee would fix a fee, and any school found to be charging more than the fee fixed by the committee will be penalized. The recognition that the school gets from the state can be taken away, the NOC can be taken away, and also fines can be asked for. And if any school finds that the fee fixed by this committee is not, I would say easy for them, or is very harsh, then they can appeal to the appellate authority, and they can also file an application, mentioning all their extra expenditures, so that the committee can consider and then allow that extra fee that they want to charge. But it has to be highly regulated. This was what the model proposed. And it proposed that for judging how much fee the school should charge, there would be a PTA, a Parent Teachers Association, from the school itself. And of course, they would have full knowledge about the school services and how much it was charging. And the PTA's word would be of the maximum importance in deciding this fee amount. So the parents had very good representation in this, because the management's participation in this PTA was restricted to 25%. So it was a really good model. And after the model came about, I think Gujarat enacted a law, and Chhattisgarh enacted a law, and West Bengal, our state, had made a commission with 16 members. There were 16 members in this fee regulatory commission, and I think the commission still exists, but for some reason we don't know what happened after that. So in 2017, this commission was first proposed in West Bengal and came about, but no law has been enacted to that effect. So this is a fairly extensive process. Even if work starts, it's going to take some few years now. And one thing is very interesting is that Tamil Nadu enacted this the first after the RTE came about, and the Tamil Nadu Regulatory Act has seen a complete trajectory. It has been challenged in the Madras High Court. When the High Court declared that the law is constitutional, then they went to the Supreme Court with their SLPs. All SLPs were dismissed. Then they came back to the Madras High Court with a revision application. Even that the schools lost. And then minority schools in Tamil Nadu also approached the High Court, and even they lost. So after everything was done and dusted, the law is still in place. And the same thing has happened in Gujarat. Same thing is happening in other states. So we hope that in Bengal also we can finally get a law out of this, and it will uphold.
As we're talking about the National Commission giving out a national regulatory framework for charging fees, can we look forward to a national legislation on fee regulation? Number one. Number two, my second part of the question is, what is the response of the state of West Bengal and as well as the central boards in enacting regulations with regards to fee structure, just like Gujarat, Tamil Nadu, Assam, states and many other states have already done that?
Unfortunately, the center cannot regulate school fees at the state level or for all states under a general law. The center can definitely make policies on education as to what is going to be, the structure or the syllabus, and how the schools are going to operate, how the teachers are going to be admitted into the school, what is going to be teacher-student ratio, like the NEP, the National Education Policy. But then how much fee every school in the different states can charge, I'm afraid the center cannot regulate on it, because the main reason here is, like I mentioned, every school in the state has to get an NOC from the state government, and it has to get recognition from the state government. So the moment these two things are given out by the state government, the center's role in this becomes very limited. And since we are a federal structure, none of these factions can, supersede the other. And at least for matters that are in the state list, which education is. Now, the state government definitely can regulate school fee because the state was supposed to create so many government schools in the state that there was no need for private schools. But since that's not the case, the state delegates its duty, the state government delegates its duty to the private institutions in the state. So, no, I don't think there can be a fee regulatory law, which is a union law and that applies to all the states. And your second question was, I think, what happens, what is the role of the certification boards in this issue of fee regulation? So, you know what? See, before a school is affiliated to any of these boards, be it the government boards, which is the West Bengal Secondary Education Board here, and be it the private boards, CBSE, ICSE, or the international boards, they all provide affiliation to the schools on the condition that the school will stand by all the necessities and all the regulations that are imposed on it by the state government. That's one criteria. But their bylaws are not very specific or detailed as to what happens when the school doesn't do this or doesn't do that. I think only the CBSE has in its bylaws one point that the fee charged by the school has to be commensurate with the facilities provided. Otherwise, the school can lose affiliation or the board can charge fine to the school. But other than that, there is not very specific fee regulatory mechanisms in place for the from the certification board sides. Now, coming to what the state government in Bengal has done or said in this matter. So, like I said, they had issued 4 government circulars requesting the schools to, not exploit the parents in the pandemic and to charge fee which was justifiable, but these were not enforceable. So, the Learned Advocate General of our state has actually been very, considerate in the arguments, and he's requested schools again and again to consider the case, but unfortunately, none of it is enforceable. Now, there is one article in the Constitution, which is Article 162, whereby the executive orders passed by the state have a legal effect. So, even in the absence of a law, if the state chooses to invoke Article 162, then it would have implementation. But they have not done that. Even otherwise, since the schools cannot be seen to be making profits, the state government still has a role, but it's very limited. They cannot ask the schools to show their accounts, and without them showing their accounts, no one will know what is the nature or amount of profit being made. So our government is unfortunately very restricted in its approach because of the fact that there is no law here. And like I mentioned, in our case, writ petition 5890 of 2020, our main fight is that we need to get guidelines or directions from the judges in the absence of a law. So a very parallel example would be what happened in the Vishaka case, Vishaka versus State of Rajasthan, in wherein there was a clear absence of law to, charge responsibility for harassment or sexual harassment of women in the workplace. And the Supreme Court gave out certain guidelines and directions which were in the nature of law of the land. And then the same evolved into the form of an enacted law by the legislature. So that's our plan. That's what our goal is. And we hope that that happens. So what we seek out of this petition is 2 things. One is a general reduction for all parents and a case-to-case reduction for special parents. And the second thing is that we would request the Honorable Court to help streamline the process of a fee regulating act in West Bengal.
Anything more that you would like the viewers to hear, or any suggestions from your side with regards to this matter?
I would just say that, see, it's a very personal suggestion because I've seen parents grapple with this issue in the pandemic. Because it's a fact that in Indian parent situation, they spend almost 30 to 35% of their income on the child's education. So when you are putting your child into a school, please, do your thorough research about the management, about the kind of services you will get, and what is the I would say ethical establishment from the school side, and how ethically sound they are. Because otherwise, many parents have been troubled in this period. That's one. And the other thing I would say is that even if schools, there are a lot of schools which are being very considerate. They are not expelling students from online classes for non-payment of fees. They are not forcing students to pay up in order to appear for their board examinations. But there are some which are doing this also. So in case this happens with you, now that you know that there is a Facebook group for this, which is protest against fee charge in the COVID, please join it. Please write to us because we really address every issue. And if you don't do that, then just remember that this is not the end of your life. Online classes or no online classes, the schools will not, rusticate you. So just be at peace. If your parents really are having a lot of issues paying up, then don't force them, and know that your knowledge and your evolution is in your hands. And for you lawyer guys, I mean, I would say that you have a lot of power in your hands because you have the power to help. The legal policies in the country, and you have the power to be an officer of the court, and you have the power to help the court understand issues which are so pertinent. So please wield that power. We all will make a lot of money in this, no issue to that, but along with that, please also address the public interest side, because you really are meant to perform a noble profession.
Thank you, Ms. Priyanka Agarwal, for being the voice of the nation and also to address the issue at hand, which is really pertinent when it comes to education and schooling. And also, I extend my heartful greetings to Mr. Vinny Guria in this regard, who took a step forward to approach the Honorable High Court of Calcutta to address this issue. Thank you for the video session with the Column of Curae, and hope you have a great day ahead.
Thank you so much.